Dictation starts. Since the learned senior counsel on behalf of the appellant has extensively relied on the judgment of this court passed in support of the proposition that a tenant is protected from any ejectment proceedings under the Surface Act, we have to examine if the law declared by these rulings accurately reflects the legal position and if these rulings applies to the facts of the present case. Para. Before we proceed further, the circumstances which led to the enactment of the Surface Act deserve close scrutiny. The Surface Act was enacted in response to a scenario where slow-paced recovery and staggering amounts of non-performing assets were looming over the banks. In order to overcome the practical reality and keep in pace with the changing commercial world, Narsimham Committee 1 and 2 were constituted by the central government to provide solutions for the issues plaguing the banking system of the country. The present act is a culmination of the suggestions made by the aforesaid committees intended to enable the bank to resolve the issue of liquidity and aim for the reduction in the number of non-performing assets. The preamble to the Act emphasizes upon the efficient and expeditious recovery of bad debts. This is also evident from the scheme of the Act. Para. Section 13 of the Surface Act provides for the enforcement of security interest. This is a self-executory mechanism for the banks. Once the process of realizing the secured interest takes place, the secured creditor acts as trustee, having de jure symbolic possessions of the property and is required by law to realize it strictly in accordance with the provisions of Section 13, 14 and 15 of the Surface Act. Crucially, subsection 2 of Section 13. Over. Thank you.